Yeah, good morning. Continuing the starts with the Supreme Court, Part 1, Establishment of the Supreme Court. There shall be a Supreme Court for Jamaica which has jurisdictions and powers that may be conferred upon by its constitution or any other law. The judges of the Supreme Court shall be the Chief Judge, a senior person judge, and such number of other pure-seen judges as may be prescribed by Parliament. No office of Judge of Supreme Court shall be abolished where there is a substantive holder thereof. The Supreme Court shall be a superior court of record, and save as otherwise provided by Parliament, shall have all the powers of such court. Next point is the appointment of judges of Supreme Court. The Chief Judge shall be appointed by Governor General by instrument on the broad seal on the recommendation of the Prime Minister after consultation with the leader of the opposition. The preceding judges shall be appointed by the Governor General. The qualifications for appointment as a judge of Supreme Court shall be such as prescribed under law for the time being in force, provided that the person who has been appointed as a judge of Supreme Court may continue in office notwithstanding any subsequent variations in the qualifications so prescribed. The next point is acting judges. In the office of the Chief Justice is, if the office of the Chief Justice is vacant, or if the Chief Justice is for any reason unable to perform functions of the office, then a person shall be appointed to that office and assume its function, or as the cause may be, until the Chief Justice has resumed those functions. They shall be performed by such person that is qualified under subsection 3 of this section of the Constitution as appointed judge. The Governor General, acting with the advice of the Governor General, acting in accordance with the Prime Minister, may appoint such person under an instrument of broad seal. If the office of preceding judge of the Supreme Court is vacant, or if any such judge appointed, the Chief Judge or Judge of Court of Appeal for any reason is unable to perform that function of his office, the Governor General, it's basically the same thing. If they're qualified to do it, they will just replace it with someone else who is qualified with the advice of the Prime Minister. And the tenure of the office of judges of Supreme Court is subject to the provisions of section 47 of this section. The judge of Supreme Court shall hold office until he attains the age of 70 years, provided that he may resign at any time in the duration of his office, notwithstanding that he attained the age at which he is required under the provisions of this section to vacate his office. A person holding the office of the Judge of Supreme Court may, with the permission of the Governor General, act in accordance with the advice of the Prime Minister to continue in office for such period after attaining the age as may be necessary to enable him to deliver a judgment or to do any other thing in relation to proceedings that were commenced before him before he attained that age, which is 70. Nothing done by a judge of Supreme Court shall be invalid by reason only that he attained the age at which he is required by the section to vacate office. A judge of Supreme Court may be removed from office for inability to discharge his functions, whether arising from infirmity of body or mind, or for misbehavior, and shall not be removed except in accordance with the provision of this subsection. A judge of Supreme Court shall be removed from office by the Governor General under the instrument of broad seal for question of the removal of that judge from his office has to be made in pursuant of subsection 6 and be referred by Her Majesty to the Judicial Committee of Her Majesty's Privy Council under section 4. If the Prime Minister, in the case of the Chief Justice, after the consultation with the Governor General, is removing the Judge of the Supreme Court for inability, as aforesaid, for misbehavior, or to be investigated, then the Governor General shall appoint a tribunal which consists of chairman and not less than 2 other members, selected by the Governor General on advice of the Prime Minister. From among those persons who hold or have held the office of judge of a court, or having unlimited jurisdiction in a civil criminal matter in some part of the Commonwealth, or having judged in appeals from any such court, the tribunal shall inquire into the matter and report the fact thereof to the Governor General, and recommend the Governor General whether he should request that the question of removal of judge shall be referred to Her Majesty by Her Majesty to the Judicial Committee. If the tribunal so recommends, the Governor General shall request that the question shall be referred accordingly. The provisions of the Commission of Laws of Inquiry, as enforced immediately before appointed, they shall, subject to provision of this section, to the 3rd schedule of the Constitution apply, as nearly as may be in relation to the tribunal appointed under subsection 6, or as the context may require, to members thereof as they apply in relation to commissions or commissioners appointed under the law, and for that purpose shall have effect as if they formed part of this Constitution. If the question of removing a judge of the Supreme Court from office has been referred to a tribunal appointed under subsection 6 of this section, the Governor General acted in accordance with the advice of the Prime Minister. In the case of the Chief Justice, or in the case of the Chief Justice after has been consulted with the Prime Minister. Any such suspension may at any time be revoked by the Governor General, acting in accordance with the advice of the Prime Minister or Chief Justice. If the tribunal recommends to the Governor General that he should not request that the question of the removal of the judge from office shall be referred to by Her Majesty to the Judicial Committee, or the Judicial Committee advises Her Majesty that the judge ought not to be removed from office. And the next point is remuneration of judges of Supreme Court. 1. The judges of Supreme Court shall receive such annulments and be subject to such other terms and conditions of service as may from time to time be prescribed by or under any law, provided that the emoluments and terms and conditions of service of such judge other than allowance that are not taken into account computing pension shall not be altered to his disadvantage during his continuance of office. The salaries for the time being payable to the Supreme Court judge under this Constitution shall be changed on and paid out of the consolidated fund. Oaths to be taken by the judges of the Supreme Court. A judge of the Supreme Court shall not enter upon duties of his office unless he has taken and subscribed the oath of allegiance and judicial oath in the form set out on the 1st schedule of this Constitution. Second part of this chapter is the Court of Appeal. Establishment of Court of Appeal. There shall be a Court of Appeal for Jamaica, which shall have jurisdiction and powers and may be conferred upon by this Constitution or any other law. The judges of the Court of Appeal shall be A president, B, Chief Justice by virtue of his office as head of judiciary, but however shall not sit in the Court of Appeal unless there are at least 4 other judges sitting, and unless he has been invited so to sit by the president of the court. C, 3 other judges and such number if any other judges may not be prescribed by Parliament. The President of the Court of Appeal shall be responsible for the arrangement of the work of the court and shall preside whenever he is sitting in court. No office of Judge of Court of Appeal shall be abolished while there is a substantive holder thereof. The Court of Appeal shall be a superior court of record and, save as otherwise provided by Parliament, shall have all the powers of such a court. The President of the Court of Appeal shall be appointed by the Governor General by instrument under broad seal on the recommendation of the Prime Minister after consultation with the Leader of Opposition. The other judges of Court of Appeal shall be appointed by the Governor General by instrument under broad seal, acting on the advice of the Judicial Service Commission. The qualification for appointment as a judge of Court of Appeal shall be such as may be prescribed by any law for the time being in force, provided that a person who has been appointed as a judge of Supreme Court appeal may continue in office, notwithstanding any subsequent variations in the qualifications so prescribed. And this part goes into the detailing of the acting judges of Court of Appeal, and it says the office of president, and it's basically the same form we follow. So they will, on advice of the Prime Minister, the Governor General shall appoint someone of equal qualification if they're not in Parliament. So this is the trend that it follows, basically. And they shall perform said functions until further notice, basically. And this next one goes into the tenure, and the tenure is similar to the Judge of Supreme Court. It goes up to 70 years, and the tenure shall end in 70 years unless they're actively in a case that should be tried. So that's the pattern there. So the age of retirement for judges of the Court of Appeal and Supreme Court is 70 years, but they may resign anytime. However, there shall be provisions if they are currently trying or had started to try a case, there could be an extension on their retirement age. And the next point is remuneration. The judges of Court of Appeal shall receive such annulments and be subject to other terms and conditions of service, and as may be from time to time be prescribed by any law, provided that the annulments and terms and conditions of service of such job, other than allowance, that are not taken into account the computing of pensions. So basically, what it's saying for the both of them, like for the judges of Court of Appeal and the Supreme Court judge, if they had a set pension plan that they had expected upon retirement, that should not change based on the change of the current salary that they're making. Because, for example, they're making $100,000, right? And that $100,000 decreased to $95,000. The compensation of the pension plan shall be taken out of the original agreement. However, they can still have a reduction in salary. But the pension plan has to be as expected, and it may come from the consolidated fund. And there shall be no less than 3 judges of the Court of Appeal. And part 3, appeals to Her Majesty in Council. Appeals from the Court of Appeal to Her Majesty in Council. 1. An appeal shall lie from decisions of the Court of Appeal to Her Majesty in Council as right of right in the following cases. A. Where there is a matter in dispute and the appeal to Her Majesty in Council is of value of £500 or upward, or where the appeal involves directly or indirectly a claim to or question respecting property or a right of value of £500 or upward. The final decisions in every civil proceeding. Final decisions in proceedings of dissolution or nullity of marriage. Final decision in any civil, criminal, or other proceedings on question as to the interpretation of this Constitution. Such other cases that may be prescribed by Parliament. An appeal shall lie from decision of the Court of Appeal to Her Majesty in Council with leave of the Court of Appeal in the following cases. A. Where in the opinion of the Court of Appeal, the question involved in the appeal is one that, by reason of its great general public importance or otherwise, ought to be submitted to Her Majesty in Council. Decision in any civil proceeding and such other cases as may be prescribed by Parliament. Nothing in this section affect any right of Her Majesty to grant special leave to appeal from decision of Court of Appeal to Her Majesty in Council in any civil or criminal matter. And the part 4 says the Judicial Services Commission. Composition of the Judicial Services Commission. There shall be a Judicial Services Commission for Jamaica. The members of the Judicial Services Commission shall be Chief Justice, who shall be the chairman, President of the Court of Appeal, the Chairman of the Public Service Commission, and 3 other members, herein after called the appointed members, appointed in accordance with provisions of subsection 3 of this section. The appointed members shall be appointed by Governor General by instrument under broad seal, acting on the recommendation of Prime Minister after consultation with the Leader of Opposition. 1. From among persons who hold or have held office as a judge of court having unlimited jurisdiction in a civil and criminal matter in some part of the Commonwealth, or a court having jurisdiction in appeals from any such court. 2. From a list of 6 persons, no one of whom is an attorney at law in active practice, submitted by the General Legal Counsel. And in part C says deleted by Act 15 of 1971. So there was an amendment which is no longer there. The office of an appointed member of Judicial Service Commission shall be vacant if the expiration of the 3 years from the date of his appointment or such earlier time may be specified by instrument under which he was appointed. If he resigns the office, if he is appointed to the office of President of the Court of Appeal, Chief Justice, Chairman of the Public Service, or any other public office except a member of the Public Service Commission or a member of the Police Services Commission. If the Governor General, acting on recommendation of the Prime Minister after consultation with the opposition leader, directs that he shall be removed from office for inability to discharge the functions thereof, provided that if he is appointed member of the Court of Appeal or a judge of the Supreme Court, he shall not be removed unless in accordance with provisions of Section 106 or Section 100. If the office of an appointed member is vacant or an appointed member is for any reason unable to perform this function, it basically goes into the same pattern where someone else of suitable qualifications shall be appointed under broad seal unless his appointed has been revoked by the Governor General or the Council, or Her Majesty's Council. An appointment shall not, within a period of 3 years, commencing with the date on which he last held or acted in the office appointed, shall be eligible for appointment. So any office power to make appointments to which is vested by Constitution in the Governor General acting on advice of the Judicial Services Commission. The appointed members shall receive such salaries and may from time to time be prescribed under law by resolution of the House of Representatives, provided that no such resolution may reduce salary or allowance from the time being prescribed under law. And appointment of judicial officers, other judicial officers. The power to make appointment to judicial office to which this section applies is subject to provisions of sections 3 and 4 of the section to remove and to exercise disciplinary control over persons holding or acting in such offices is hereby vested in the Governor General acting on the advice of the Judicial Services Commission. And we notice that most of these, this arm of government, the judiciary, the advice comes from the Judicial Services Commission and not necessarily the executive, whereas the executive is also involved at the higher level. But most of the judiciary is controlled by the Judicial Services Commission and not the House of Parliament. And this goes hand in hand with the separation of powers, basically, of the government, the three arms of government. It says, where a referee is made to the Privy Council under provisions of Section 3 of this section, the Privy Council shall consider the case and shall advise the Governor General as what action shall be taken in respect to the officer, and the Governor General shall act in accordance with such advice. And the last point under this chapter says, delegation of functions of Judicial Service Commission. The Governor General acting on the advice of the Judicial Services Commission may, by instrument on the broad seal, direct that, subject to such conditions, may specify in that instrument power to make appointments to such offices may be specified, bringing office to which Section 112 of this Constitution applies, as may be so specified without prejudice to exercise such power by the Governor General acting on advice of the Judicial Services Commission, be exercisable by such one or more members of the Commission, or by such other authority or public officer as may be so specified. But in any case where the person to be appointed under this section holds or is acting in any office power to make appointments to which is vested by this Constitution in the Governor General acting on the advice of the Public Service Commission or the Police Service Commission, the person or authority specified in the aforesaid instrument shall consult with the Public Service Commission or the Police Service Commission as case may be before making such an appointment. So this part goes more into judiciary, and that's the end of chapter 7 basically. And the next chapter will touch on finances, which is exciting and looking forward to that one. But that's all for today. So next time.